What really happened? That's the question many people are asking after Drushantha Ramsamy made explosive allegations against Andrea Johnson. He claims she ignored the IDAC Bible and made what he described as a flip-flop knee-jerk decision, a statement that has quickly sparked heated debate. Before we continue, please kindly subscribe, like and comment your opinion below. But is there more to this story than meets the eye? Supporters argue the decisions were justified, while critics say important procedures may have been overlooked.
And when the deviation was done, it always came with intimidation.
Can you explain intimidation in this context?
Am I allowed to say it as we say it in the office?
Yes, please.
The nickname for Advocate Johnson in the office is flip-flop, knee-jerk.
Okay, just explain that.
You would get instructions in the morning. Can I speak from my personal experience now? Okay.
Yes, please.
You would get instructions, or you would have a conversation with Advocate Johnson in the morning, or telephonically, or via WhatsApp. And it would be just the two of you, or maybe another prosecutor and you. And you would find commonality, or you would explain the legalities, the processes. I mean, the elements of an offense changes, but the principles of law does not change. If you have a document in a murder matter, it doesn't change when you're trying to prove it in a corruption matter. So you would have those engagements with her. And then during the course of the day, there would be a conversation that would take place between Mr. Perumal and Dylan Perumal and Advocate Johnson. And the flip-flop would happen. So no matter how you explained it to her or how the decision was made in a rational manner, it would then change according to what Mr. Perumal wanted. And my evidence will show how that affected the investigations.
And when you were engaging Advocate Johnson without Mr. Perumal, did you find that you were then speaking to somebody that was legally trained, a prosecutor? Was there that level of engagement?
Yes. When Mr. Perumal was not present or was not involved in the communication or was not influencing the decisions, Advocate Johnson was a very active legal mind. You would be able to engage, and she would speak about different things that she had done and how we can incorporate it and sections of acts. But then come Mr. Perumal, all of that is thrown out the door. And we are now doing things that we're not even supposed to be doing. And it is becoming an instruction. And Chair, from 2023, let me speak for me rather.
With both sides standing their ground, the controversy is only growing. Will Andrea Johnson respond to these claims? Could this change public opinion, or will new evidence tell a different story? Stay with us as we break down every key detail. Don't forget to like, subscribe, and turn on notifications so you never miss an update.
No, I'm going to speak collectively as the prosecutors of IDAC, because we are all, majority of us are rocking in this boat. If you defy an instruction of Advocate Johnson, or you contradict her, the reign or the wrath, if you have to, may I speak about, if you have to go and check the records at the wellness program that NPA provides for its employees with regards to just work stress, home stress, counseling, you will be shocked at the amount of prosecutors and employees, admin staff from IDAC that are receiving counseling.
Is that not because of the nature of the work you do? Just explain.
No, Commissioner.
Yeah, please explain.
May I deviate? Am I allowed to deviate?
Slightly.
Slightly. Okay. If you don't follow the instructions, you receive emails of a nature that, when I was consulting with the DPCI officer, when I intended on making protected disclosure in June last year, I likened it to being treated worse than scullery maid. You would be internally investigated, unlawfully so. You would be made, I was made redundant for an entire period in 2023 because I objected to Mr. Perumal and Advocate Johnson. And it happened again this year because I objected.
And when you say internal investigations, what mechanisms would she adopt?
Okay, now I'm jumping ahead of my evidence. I apologize. Section 28 does not have any checks and balances. And it can be likened to a 205, a Section 205 of the Criminal Procedure Act. It's invasive. It's exceptionally invasive. But Section 205 of the Criminal Procedure Act allows for a person to make submissions to a magistrate or a judge to explain why we are now invading this person's privacy or we need this information. Section 28 allows unlimited control by one person without any checks or balances. And that is how we were investigated, through that.
Except, of course, that even if in Section 28 itself there may be no specific provisions, the Constitution is an overarching document. So Section 28 would still have to be applied with the Constitution or the privacy right in mind, if you see what I mean.
Correct. And
Yes.
my evidence, not very far down the pages, does deal with how this is so severely abused and how it continued since my start at the ID to be abused. Sorry, I could see.
No, that's fine.
Still on this, on the operations manual, the impression, I don't know if it's just me, but the impression that I gained from Advocate Johnson's evidence about this, the existence and application of an operations manual, was that, yes, there is such a document, but we don't operate according to it. So the impression I had was, it's sitting somewhere in a computer or on your mainframe, but in fact, it's more, you just go about doing your things and people exercise their discretion at any one time in meetings without this ever being applied. Is that correct? Because you speak of it as a deviation. In your testimony, you say she deviated from what this prescribed. Is that deviation as a matter of course? That's what happened, and therefore this was just good on paper for all intents and purposes.
It's applied as and when Advocate Johnson wanted to use it.
All right, I'm answered. Thank you.
Okay, we can go back to your statement, paragraph 6. The 6th line, the sentence that starts, I will explain. I will explain why this did not sit well with me.
Page 3.
Yes, page 3, paragraph 6. You'll see after you deal with the 3 points, you then say, I refer in particular to the application for authorization. Do you have that?
Yes.
You can read from there.
I refer in particular to the application for authorization of a Section 2813 investigation that I prepared on the 5th of December 2024. I will explain why this did not sit well with me. However, the commissioners must bear in mind that at this point, Advocate Johnson had stated they had made a decision that the matter was to proceed in terms of Section 2813, and that I was to draft the authorization and email it to her on the same day that the referral was handed to me, because she wanted to approve it by Friday, the 6th of December 2024. I deal with this fully later in the statement.
Continue.
On or about the 30th of June 2025, after the Mokwela arrest and the first appearance, I contacted a DPCI officer. I must state I trust this DPCI officer, which is why I contacted him, to inform him that there's a problem at IDAC and that I need to see him and explain and show him the documentation that I had in my possession. I asked if I could if I could do protected disclosure. We agreed to meet on the 2nd of July 2025, where I showed him a prosecutorial memo prepared by me and another prosecutor regarding the matter of General Masiamula and Lieutenant General Kumalo, which I deal with later. He said that he would speak to a colonel at the DPCI and get back to me as to how we were to proceed. The reason that I contacted DPCI is because I had previously, in late April 2025, informed Advocate Santos Manilong, the DDPP that I report to, of the discord amongst the team being that of the crime intelligence investigation, and that the investigation procedures were being flouted and that the investigation was sloppy. He replied that he had his own problems. In August 2025, I started collating documents regarding what I considered to be unlawful instructions from Advocate Johnson and Mr. Perumal regarding project diversion. May I proceed?
Ms. Ramsamy, sorry. When Advocate Manilal says he has his own problems, was it about the same issue, the crime intelligence investigation, or?
He had not, although he was on paper as the deputy director, he had not been briefed on the matter, which I do discuss later on in the statement.
The question I'm asking is, when he said he has his own problems, did you understand him to mean about the same subject, the same investigation, or he had his own problems within IDEC? I'm just trying to understand what it is he was.
I understood it to mean that he was not interested in my problems and this project.
I see. Yes, thank you. That answers me. Thank you.
Okay, continue.
On the 8th of August 2025, Advocate Peter Surunye, a Deputy Director of Public Prosecution, came on board the Mokwela and Lushaba cases. He started sending emails and memoranda that accorded with my concerns on how the Mokwela matter was being conducted. Advocate Drushantha Ramsamy and I also approached Advocate Surunye with our concerns. He can confirm this to the Commission. When Advocate Surunye requested to be removed from the Mokwela and Lushaba cases, I was removed from the Mokwela case, and although I was apparently kept on the Lushaba case, I was excluded from the case from September 2025. I also approached another deputy director and showed him all the documentation that were concerning. He stated, "These things will never come to light." In November 2025, after Advocate Johnson testified at the ad hoc committee, I contacted the same officer at the DPCI. I informed him that Advocate Johnson had lied to the ad hoc committee and that I had proof of this. Once the new NDPP, Advocate Motibi, was appointed, I met with the DPCI officer. This would have been around March 2026.
Can I just interject to ask you why it's significant that you mention once the new NDPP was appointed? Did you meet with the DPCI officer?
Because I knew that if I had reported or we had taken these concerns to the then sitting NDPP, nothing would have been done. Advocate Johnson, there would be no repercussions, there would be no corrective measures.
By that you mean Advocate Shamila Batoy?
Correct.
Why would you have formed that opinion?
I was aware of the matter that was discussed with the commission about the sharing of documents, but that was corridor talk, so I wasn't confirmed. But if I may put it frankly, from a prosecutor's point of view that's in the office every day, Advocate Johnson was the blue-eyed girl of Advocate Batoy. She could do no wrong. If needs be, or if the commission so sees fit, if you look at any grievance that was sent about IDAC from the staff members, it was squashed to an extent where people started just resigning. People were applying for posts. I'm an SA. I've been applying for SA posts just to get out of that unit.
And you referred to the sharing of documents. Are you talking about what Mr. Rulof said, Mr. McLean, and Witness O said about the sharing of a docket by Advocate Johnson with General Khan? Is that what you are referring to?
Correct, but at that time, before the testimony, it was just corridor gossip.
Thank you, thank you.